With the legal studies exam just a few minutes away, I'll be covering 10 of the most important guaranteed questions that you'll see in the exam today and ensure that you score a solid 200 out of 200 in this CUET domain subject. So without any further ado, let's begin. Some guidelines for the video: there'll be 10 important guaranteed questions. Take 5 seconds to pause and answer yourself, and then immediately afterwards there'll be a solution and a discussion that follows. So without any further ado, let's actually begin right now. Question number 1. Identify the correct statement. A. Arbitration and mediation are confidential in nature. B. Arbitral award is enforced as a judgment of the court. C. Mediation settlement cannot be challenged. D. Mediation cannot be coupled with arbitration. And E. The difference between mediator and conciliator is the role of the neutral party. Choose the correct answer from the options given below. 1. A, B, C, D only. 2. A, B, E only. 3. E only. And 4. A, B, D only. The answer is option 2, A, B, E only. So the concept that you have to utilize here is obviously that if you look at statement C, it says that mediation settlement cannot be challenged, but the truth is it can. One of the most fundamental benefits of alternative dispute resolutions mechanisms is that they're not binding on the parties. They can be challenged and struck down by a court, an actual court, like a Supreme Court or a High Court. So obviously this statement is incorrect because it's saying that mediation cannot be challenged, while it can be. And coming to statement D, it says that mediation cannot be coupled with arbitration. This is obviously also wrong, because if you look at the types of arbitration or the types of mediation, we know that one of them is mediation coupled with arbitration. So that leaves A, B, and E, which are all correct options because it says they're both confidential, which is true. The arbitral award can be enforced as judgment of the court, and the difference between mediator and conciliator is the role of the neutral party. So all A, B, and E are all correct, so that's obviously leaves option 2 as the correct answer. Now coming to question 2, this is a very fundamental question, which is matching fundamental rights and which right they actually provide. So we have to know a definition of all the rights. Take a few seconds to pause the video and solve it. So the answer is obviously option 1, A3, B4, C2, and D1. So this was from a previous year question paper of last year, and the question itself was inherently wrong because Article 32, as you all know, is right to constitutional remedies, and that's nowhere mentioned in list 1. So right against exploitation is Article 23, which is not provided in list 2. That's why we can just use the other options. So we know that right to life is Article 21, so we can match A with 3. We know right to equality is Article 14, so we can match B with 4. And then right to education is Article 21A, which was part of the 86th Constitutional Amendment Act of 2002. So that leaves us with A3, B4, C2, option 1. Next question. Which of the following statements are true about international law? A. It's a framework of rules and principles binding the relation between states. B. It's derived from constitutional law. C. It's a body of law that governs the conduct of states among themselves. And D. It governs the conduct of institutions of national importance. So right off the bat, if we look at this question, we can immediately eliminate option D because it says institutions of national importance, but the correct option should be of international importance. So we can eliminate D. And if we look at the options, only 2 of the statements can be correct. Therefore, we have to eliminate one more statement. If we look at B here, it says it's derived from constitutional law, but that's obviously not true because there's no such thing as an international constitution or one single binding document that applies to all countries. We only have constitutions for separate states and separate countries. Therefore, even option B is eliminated. Therefore, the answer is A and C only. Moving on. Question number 4. In which of the following cases the court highlighted that for a valid contract, it is important to create legal obligations on the parties? 1. Carlyle versus Carbolic Smoke Ball Company. 2. Balfour versus Balfour. 3. Lalman Shukla versus Gauri Dutt. Or 4. Powell versus Lee. Take a few seconds to pause and answer. Yes, the answer is option 2, Balfour versus Balfour. Obviously, if you read the textbook, then you know that we don't have option 3 or 4 in our curriculum at all. So obviously that's not a valid explanation, but usually since the CUET exam is wholly based on CBSE and NCERT curriculum, we can eliminate these two options, 3 and 4. Now, deciding between 1 and 2, we know that 1, this first option, Carler versus Carbolic Smoke Ball Company, it's completely about the general offer, which is a contract made to the public at large, because the plaintiff filed a case as the company had falsely advertised that they were giving £100 as a reward to anyone who contracted a disease after using the medicine. It's a long story. I'm not going to explain the entire case, but this case, it's all about general offer and how acceptance for general offer doesn't have to be conveyed necessarily for a valid contract. But the question is not asking about general offer or any of those. It's asking for a difference between a valid contract and a not invalid contract. So that can leave us with only one option, Balfour versus Balfour. If you recall, that case is about how there was a moral obligation for one of the parties to pay the other party, but there's no legal obligation. So that's why a valid contract has to contain legal obligations and not simply moral obligation. That's why the answer is option 2. Remember, it's not always about knowing the concept. It's also about educated elimination, educated guesses sometimes. Question number 5. Which of the following articles is the most authoritative source of international law? Article 27 of the UN Charter, Article 96 of the UN Charter, Article 38 of the Statute of the International Court of Justice, Article 41 of the Statute of the International Court of Justice. So this is a pretty standard question. It requires conceptual understanding and just going through the book in general. If you know that it's not in the UN Charter, which is true, you can eliminate option 1 and 2. And that leaves us with 3 and 4. And this is a pretty straight up question. We have to know it's Article 38, Clause 3 of the Statute of the International Court of Justice, which states the 3 sources of international law. So the answer is option 3. Moving on, question number 6. Sanjay lies to Mrs. Gupta that her son met with a road accident. As a result, she suffers a nervous shock resulting in her illness. Sanjay is liable for 1. Negligence, 2. Strict liability, 3. Unlawful harassment, or 4. Conversion. The answer is unlawful harassment. So we know that negligence requires an establishment of a duty of care and then a violation of that duty of care, which results in a harm. And strict liability, it's a rare case when even though there's no fault of the plaintiff, he's still liable to pay damages for the rights violated. We have unlawful harassment and we have conversion. We know the conversion is related to property, so we can easily eliminate that. Negligence is also can be eliminated because there's no duty of care or anything established in the question. And we can also eliminate strict liability because there's definitely intent of the defendant, Sanjay, to cause harm to the plaintiff, Mrs. Gupta. So that leaves us with unlawful harassment. And we know that unlawful harassment occurs when, without physical force, the defendant is still causing harm, either physical or mental, to the plaintiff. So by lying, which is not necessarily a physical act, by telling a lie, he's resulting in the harm of Mrs. Gupta. So obviously the answer is 3. Question number 7. Every person who has to file or defend a case shall be entitled to free legal services under the Legal Service Authorities Act of 1987 if the person is A. a woman or a child or even an animal, B. a member of scheduled caste, C. a member of scheduled tribes, D. an individual workman, E. a victim of trafficking in human beings, or beggars. Choose the correct option from the options given below. A only, A, B, and C only, C and D only, B, C, D, and E only. So if you can eliminate one of these options, then you obviously already have the answer. So look closely at option A. A woman or a child or even an animal. This is obviously not true. Animals do not have free legal services. In fact, they don't approach the courts to settle justice either. So we can immediately eliminate option A. That leaves us with B, C, D, and E. B is true, C is true, D is true, and E is also true. So the option is 4, A, B, C, D, and E only. Question number 8. In the legal maxim actus non facit reum nisi mensit rea, actus rea stands for 1. Malified intention, 2. Guilty act, 3. Bona fide intention, or 4. Act allowed by law. Legal maxims are obviously a very important part of legal studies, and in the CUET syllabus, they prescribed about 50 legal maxims that you have to learn. The one thing I can recommend is to stick with the legal maxims provided in the CBSE textbook, because based on my analysis of previous year question papers, most of them, like this one, this is from criminal law, the chapter on criminal law, most of them are directly from the CBSE textbook. So stick to those, but also cover the CUET NTA prescribed maxims as well. Coming to this question, actus non facet reum, this is obviously related to criminal law. Actus reus means the guilty act, and mens rea means the guilty intention. So, or the malified intention. So actus means act, and that's option 2, guilty act. Question number 9. Identify the domain in which the rule of public international law do not apply. 1. Climate change, 2. Biodiversity, 3. Intellectual property, or 4. Adoption. This can be answered through that small table in the chapter on international law, which states the domains that public international law can be answered. Many of us may skip that table, thinking that it might not show up on the exam, but looky here, it does. So, if you think about it, all 3 of these are like overarching global topics: climate change, biodiversity, intellectual property. By adoption, on the other hand, it's a more private law. We can always immediately tell because it's related to families. It's not part of the public sphere necessarily. It could be part of the private sphere. So through simple elimination, we can obviously tell the answer is adoption. So our last question for the day, arrange the following in sequence of establishment: A. International Court of Justice, B. Human Rights Council, C. International Criminal Court, D. Vienna Declaration and Program of Action, and E. League of Nations. Many of us, after seeing this question, may immediately feel thrown off because we don't know the dates, therefore we can't answer the question. But this is not true. The education pattern has changed in assessment. Dates are not as relevant, but knowing the sequence is. And 9 times out of 10, the sequence can be derived by knowing a few, just at least 2 of the dates or the 2 of the sequences, and using simple logic to establish the others. So if we look at these: ICJ, Human Rights Council, International Criminal Court, VDPA, and League of Nations, obviously League of Nations happened before World War I, and these other ABCD, they seem to be established after World War II, after the establishment of the UN. We know that ICC, International Criminal Court, was established in 2002 under the Rome Statute, and we also know the Human Rights Council was established in 2006. So just by knowing that, we know League of Nations is first because it was established after World War I in the 1915, around that period of time. We don't even have to know the exact date. So if we see E as first, there's only one option. Option 2, EADCB. So that obviously leaves us only one answer by eliminating all the other ones. But even if we want to verify ourselves, we know that B is probably the last because it was in 2006. And C is probably before B because it was in 2002. So we know DCB, excuse me. So the answer is obviously option 2. That concludes this video series, which provides 10 guaranteed questions for today's CUET Legal Studies exam. Thank you so much for watching if you stayed tuned till the end, and good luck on your exam. Thank you.